Hello, everybody. Thank you so much for joining us today. My name is Juan Carlos Brando, and it's a pleasure for me to have everyone joining us in this show of attorneys with the attorney Francis Fongsan today in the law firm of Margaret W. Wong and Associates that we are usually connecting with you at 12:30 p.m. Eastern Time. And well, it's for me a pleasure to have one of the most experienced attorneys in the law firm, and I would say one of the best attorneys in some parts of the United States, and I would say one of the best in the whole country. And thank you so much, Attorney Francis, for having me today. How are you doing?
I'm good, thanks.
Thank you so much. And I would like to start by asking just what do you think is going to happen in the last month of 2023 if there is something coming?
Well, I mean, there's talk about some new laws that might be being passed now, not having specifically focus on immigration, but might have immigration consequences because they're talking about tying new rules on asylum or new rules on parole based connecting to government funding laws, which I don't think is really appropriate because those have nothing to do with the funding of the government, but some politicians trying to attach immigration changes to those bills. Now, whether that's going to happen or not, there's a lot of pushback because asylum and parole have nothing to do with those laws. So I don't think it's actually going to happen. So I think it's going to be relatively quiet this month.
Okay, so if something were or was to happen with asylum, what would change in an asylum application that I know asylum applications is more an international right according to the treaties, and not only something related to immigration in the United States. What would change regarding to that?
Well, I mean, there's already been a lot of changes this year because back in May, there was that new Biden travel ban rule where if you entered illegally into the United States since May of 2023, then you're subject to stricter rules on applying for asylum rather than because the administration wants you to apply at the border through the CBP One app to be admitted into the United States. They don't want you to enter illegally. So since May of 2023, it's been actually tougher to apply for asylum if you entered illegally after that date. Now, I don't want to speculate on what these new rules might be because nothing's been passed yet. But I think that if they're already trying to make it tough for people to enter illegally, I imagine they might even make it even more tough if you did enter illegally without going through the CBP One app.
And for example, people, and this is a question that I just received one day ago. A young lady with her husband and her daughter were trying to make it here through the southern border coming from Honduras. They were caught. I mean, no, they were not caught. They surrendered at the border, but the officers detained them and they took them for one day in the detention center. And then the next day, they took the fingerprints and a couple pictures and they sent them back to Honduras. So what they said to me is that they were told that they cannot apply for anything with the government of the United States for 5 years. So what does mean that this about this 5-year bar? They cannot even apply for asylum or any other humanitarian way to come to the United States?
Okay, so the 5-year bar is for what's called expedited removal. That means if you are at the border or near the border and the Immigration Service catches you and you are here illegally, then the US Customs can deport you. Now, if you are deported from the border, then that's a 5-year bar. You can't come back legally for 5 years, okay? And if you do come back illegally and the Immigration Service catches you, they could use that old expedited removal to deport you again. So what do they do now? Well, probably what they should have done was try to make an appointment through the CBP One app instead of just showing up at the border without an appointment. Because without an appointment, you're just some other undocumented person at the border that could be removed. Okay, so even though you have this 5-year bar, you could try to make an appointment through the app, but that means you have to make your way all the way back to the border and approach on the scheduled date and time if you can get that appointment. So that's unfortunately the only way you can get to the border again and get through, unless you have some other family member in the United States who can somehow get like a parole document for you.
Okay, thank you very much, Attorney Francis. And well, let's start with the questions that are coming in from our audience. And don't forget that the phone number to call to the office and set an appointment with one of the attorneys in the law firm is 216-279-3984. You can see it at the bottom of this screen. 216-279-3984 is the phone number that you need to call to make your appointment with the attorneys in the law firm of Margaret W. Wong Associates. Emily is asking the following. Is H-4 visa a dual intent visa?
So the answer is yes. H-4s are for spouses and minor children of H-1B workers. Dual intention means, can I be here temporarily because H-4 is limited, and also go through a green card or immigrant process? And the answer is yes. You can do both at the same time without being a risk to your H-4. That means you can extend your H-4, you can travel overseas to apply for an H-4 visa and re-enter, even if you have an ongoing green card process.
Okay, thank you so much. Don't forget, Emily, the phone number, if you need more information, is 216-279-3984, 216-279-3984. Next question is, hi, I am Venezuelan. I entered on a B2 visa when I was 12 years old. My parents applied for asylum and I have TPS. I am studying avionics engineering and would like to know if I could qualify for labor certification. I'm 20 years old at the moment. Thank you.
Okay, so the question here is whether the person is eligible for labor certification. That means an employer willing to sponsor this person for the green card. Okay, usually to qualify for labor certification and the green card, you have to show that you've been maintaining valid non-immigrant status. That means valid legal status when you apply for the green card. TPS is a valid non-immigrant status. But the question is going to be, what about the time between the expiration of your B2 visit and the approval date of your TPS? How long was that time? And how old were you during that time? Now, the Immigration Service, since you do have valid non-immigrant status right now, and you did enter legally, if you did not leave and re-enter the United States on the TPS, then technically you have more than you didn't have valid non-immigrant status before. So it's possible the Immigration Service could use that to deny your green card application. If they do that, then you would have to go overseas to finish your green card application by going through the US Embassy. But you won't have unlawful presence, so you won't need a waiver to forgive this illegal time in the United States, because time before the age of 18 does not count against you. And since the age of 18, you've had TPS. Now, what is the safer route to take? The safer route to take now, I would recommend you apply for a travel authorization based on your TPS. You use that travel authorization to leave the United States and re-enter the United States using your TPS. That means since your most recent entry date, you have valid non-immigrant status, which is the TPS, no illegal time. Then you should have no problem applying for the green card through labor certification. Okay. Now, if somebody else who's married to a US citizen, all you have to show is you entered the United States legally. So your B2 entry is what matters. The TPS isn't relevant at all. There's no problem there. But through the employment-based process, you have to show valid non-immigrant status.
Okay, thank you so much. And it's a very clear answer. Thank you for clarifying all of the details. And this person says that my dad applied for asylum within 6 months and I never left. I am included in his asylum application.
Okay, so there's a question of whether pending asylum, you can apply for a green card through an employer while you were waiting for your asylum application. A couple of years ago, there were some people who were approved, but that was pretty rare. Now, the Immigration Service will say, pending asylum is not a valid non-immigrant status, like B2, like TPS, like H-1B, like F-1. So it's unlikely they would approve the employment-based case purely based on pending asylum. It's much stronger if you use your TPS, you leave and re-enter legally, so you don't have unlawful presence problems.
Perfect. Thank you very much, Attorney Francis. Don't forget that you can call. The phone number is 216-279-3984, 216-279-3984. Emily is sending another question related to the first one. I don't know if we can answer that. What if their spouse is on H2? The individual is in H4 and has approved I-140, NIW waiting to file the I-485. Does only H-1B spouse, H-4 spouse consider dual intent?
Okay, so H-2s are for temporary workers. Could be seasonal, could be agricultural. Now, if the H-4 has the approved NIW waiting to file the 485, you probably saw the visa bulletin that the priority dates for EB2, EB3, other workers, they are retrogressed. That means you cannot file the I-140 and the I-485 at the same time right now. So you have to wait to file that I-485. Now, dual intent, usually the most common way is for the H-1B. H-2s, by definition, are temporary in nature. It's seasonal. You're here for the summer or for the spring, and then you leave when the season is done. So technically, I don't think technically H's and L's have dual intention. They don't make the distinction, but I would not depend on dual intention for the H2, okay? But this is only an issue if you decide to leave the United States and re-enter. So the question here is, what is the goal? Are you legally here in the United States right now and you're trying to stay here? Or do you plan to leave the United States, wait overseas, and try to come back in on a new H visa, and then eventually file your I-485 in the United States?
Okay, interesting question, and thank you so much. And well, actually, I met a bunch of people. It was like 12 people from Mexico that were going back to the airport last night because I think they are H2 visa, or they work in remodeling and construction companies here, but they come every year for about 6 to 8 months to work. And then last night, they were going back to Mexico, and they had a lot of luggage just going back there. So I think that they have been doing this for about 5, 6, 8 years, and they do it every single year. So is this something good, the way that they are doing it, or is there a better way that they could stay here?
Well, I mean, so if you go through labor certification, if the employer is willing to sponsor them for the green card, or they get the NIW, which is the National Interest Waiver approved, like I said before, there's a backlog. You can't apply for the green card at the same time as the I-140. You might have to wait in line for a few years for that visa number. So how do you maintain your legal status in the United States? You can't extend the H-2 because you're here for the season. So pretty much you have to leave and come back leave and come back while you're waiting for that visa number. So Emily's question was about, well, will I have a problem coming back if I've started this green card process? Will the embassy deny my temporary visa because I've started the green card process? And so I would say it's possible that they could say that your visa is not dual intention because it's technically seasonal or temporary in nature. But I mean, there's not much you can do about it. The I-140 is already approved. You have to maintain some sort of legal status. If you want to keep doing what you're doing, then you leave, apply for the new H visa, and come back for the new season.
Thank you so much.
And the alternative is, if you want to stay here, maybe you change to another status, like student or some other temporary status, but then you wouldn't be able to work legally. You have to go to school. I mean, there's other restrictions involved.
That might be a problem. Thank you so much, Attorney Francis, for clarifying this question. The next question says, I was charged with impersonation about 10 years ago in the state of Ohio. If my son wants to file for me, that would be a problem. I entered on a tourist visa on 2007, and I had a fake or phony social card only for work.
So impersonation is usually when, for example, you're driving using a driver's license that's not real or in somebody else's name. And so when you get stopped and the police ask you for your ID and you say that you give this ID that's not your name, then the police technically can charge you with fictitious or impersonation, saying that, well, it's not your real identity. So the question is that going to be a problem for the green card process? Now, if your son is a US citizen over the age of 21, that son can petition for you because you entered legally. Now, will the criminal record be a problem? As long as it is what's called a petty offense. That means the maximum jail time under the law is 1 year or less, and your actual jail sentence was 6 months or less, then this crime is petty offense. It's not as serious, so it's not a problem for you. If it's more than that, the jail sentence, then it could be a problem. I'd recommend you get your records and see an attorney, us or somebody else, in person so we can take a look at them. But we should still review those anyways. Now, the fake social for work. Now, as long as you are not claiming to be a US citizen, showing a social security card or identification to a private employer that's not a US government official is not immigration fraud. And that should not cause a problem for your green card process. If you claim to be a US citizen, then that's a problem, because claiming to be a US citizen to anybody is always an immigration problem.
Okay, thank you so much. And well, maybe that's a problem that many people can feel identified, because in some companies they ask you for a phony social security number so that they can let you work in that company. But the thing is that some people carry that in their wallet or something, and then if they get stopped by the police and they check their documents or they check their wallet, then they're going to have a problem. So you need to have a good attorney and a good representation. You can call the phone number 216-279-3984, 216-279-3984. Attorneys in the law firm of Margaret W. Wong. And it's not the same person that is asking this question, but it's very similar. So I'm going to skip a couple questions and go ahead with this one. And Jimmy says, what about having 2 misdemeanor charges in the first 5 years of acquiring my green card? Would it be a problem for getting my citizenship?
Okay, so the important question is, what were the 2 misdemeanors? Okay, certain crimes, small time, not as serious, would not be a problem. But when you, well, let's go backwards. There's 2 issues we're looking at. Number 1, can I apply for US citizenship because I've had my green card for 5 years? And the second question is the criminal record going to cause a problem for my green card itself? Will immigration try to take my green card away from me or put me in deportation? Okay, so those are 2 different questions. Question number 1, citizenship. It depends on what those misdemeanor charges are, okay? Because you have to show 5 years of good moral character, that you were a good person during those 5 years. So if the two are DUIs, for example, that's automatically no good moral character. You have to wait at least 5 years after one of the DUIs so that you don't have 2 DUIs in the past 5 years. The second question, is that a problem for my green card? We have to look at what those misdemeanors are to see if they make you deportable. We have to look at the law. What is the jail time maximum? How much time did you actually spend in jail for your conviction? Okay. And then we can figure out, is that a deportable offense? Is it a risk to apply for citizenship? Because then you'll be on immigration's radar.
Okay, thank you so much, Attorney Francis. Well, Jimmy, if you have another question, you can call. The phone number is 216-279-3984, 216-279-3984. The next question is, how long can I stay overseas if I have a green card without losing it?
Okay, so the rule is 12 months. If you stay overseas for more than 12 months, 1 year, without coming to the United States, you automatically abandon your green card. Okay, now there's a way to save it if it was out of your control. Like if you had some severe medical problems or your family had a medical problem, you couldn't leave and come back to the United States. But to protect the green card, if you need to spend some time overseas, that's more than 1 year, you should apply for a re-entry permit. That's on form I-131. That's a travel permission document, which allows you to stay overseas for at least 2 years, which will protect the green card without coming back. Okay. Now, if you stay outside the United States between 6 months and 12 months, technically your green card is okay, but when you come back to the United States, US Customs at the airport might warn you, oh, why are you spending so much time overseas? If you spend any more time, you need a re-entry permit. So you might get that warning.
Okay, and this person is sending the other part of the question and says, I came to Venezuela to renew my passport, but it's been 3 months and I'm still waiting for it. And I'm starting to be concerned about it.
Well, I mean, another problem is you can't come back to the United States without the passport. So that's something that's out of your control. You should be okay. But what if you're getting close to the 12 months, then you might want to consider, well, I mean, if you submit the I-131, maybe you can try that. You can do the I-131, you can try doing it online.
Okay, thank you so much, Attorney Francis. Don't forget, the phone number is 216-279-3984, 216-279-3984. Next question comes from our YouTube channel. It says, hi, I filed for my wife on 2021. She lives in Dominican Republic. I'd like to know how long is she going to take to come back?
Now, when you say come back, does that mean that she was previously in the United States? And if so, was she here legally or illegally? The regular sponsorship process from marriage to US citizen would take about 1 year for the I-130 petition to be approved, and then possibly another 6 months to 1 year for the interview to be scheduled at the US Embassy in the Dominican Republic. Now, if your spouse was illegally in the United States for more than 1 year, then technically she has a 10-year bar and she has to apply for a waiver to forgive that illegal time. It's called unlawful presence on form I-601A. If she needed that waiver, then that's an extra 4 years. She has to wait for that waiver to be approved before that interview at the US Embassy can be scheduled. So it's very important. You have to figure out, does she have any immigration problems that have to be taken care of, or has she been in the Dominican Republic the whole time?
Again, this person is adding something, Attorney Francis, and it says she came on a tourist visa, but went back to Dominican Republic to wait for the process since she had to finish college.
Okay, if she did not overstay the tourist visa, then she should not have an unlawful presence or 10-year bar problem. then pretty much she's waiting for that petition to be approved, submitting the visa documents, waiting for the interview. So total, I would say maybe about 2 years.
Okay, thank you so much, Attorney Francis. Well, times are very long at the moment. If we go back maybe 10 years ago, how long was the wait?
About 10 years ago, I would say it was about a year and a half. I think the
Oh,
pandemic definitely made things a lot slower just because there were a lot of these embassies were shut down. And then when they were slowly reopening, there were staffing issues. People didn't want to work overseas, or they couldn't find enough people to do the visa applications, or the embassies just didn't have full operations. So you've got all these people backlogged waiting for an interview. And so the embassy is trying to get those people interviews. New people are trying to get interviews. So now it's taking longer and longer. Sometimes the wait could be 2 years for an interview instead of just 3 months.
okay, it's very interesting, and the times are going longer and longer. Okay, the next question says, hello, sir. Thank you for this show. For a person that has experience driving 24-wheel trucks in his country, is there a way to apply for a job in the United States due to the shortage of truck commercial drivers? Thank you very much for your answer in advance.
Okay, so when I see the word shortage, usually I think of an NIW. Okay, that's a national interest waiver, where you show that it's in the benefit of the United States for this person to come to the United States and stay here, which is nationally important to the United States. I've heard of NIWs being approved for pilots because there's a shortage of pilots. But usually NIWs are for researchers, scientists, or jobs where it's important for that person to be here, or else there's a national security problem, or the United States will be worse off competitively with the rest of the world. Okay, so I don't think that commercial truck drivers would qualify for an NIW. Maybe somebody could try it. Aside from that, the shortage itself doesn't really matter. The question then is, what type of visa or process can we use to bring truck drivers into the United States? One option would be the regular labor certification process. There's a US business that wants to sponsor a foreign worker to bring them to the United States. And so you go through the labor certification process, 2 years, the person can come to the United States as a green card holder, a permanent resident. What about a temporary visa? What if this person overseas wants to invest into a US business or start a US business for commercial trucking? Then if this person is from a country that allows for E2 visas, that's the investor visa, the person could start a commercial trucking business and come to the United States to manage and work for that business. Okay, so those are two common ways to bring truckers into the United States.
Okay, thank you so much. And we have time for one last question, Attorney Francis. And let's go ahead. And the next question comes from a person from India and says, my niece came through Canada. Her parents are in India. She lives with me. She's 17, turning 18 on May 2024. Can I help her get documents?
All right, so I guess the first question is, how did she enter through Canada? Was it legally or illegally? Okay. And then the second question is, why did she come to the United States? Was it because she had issues in India? Did she have problems there? Is she afraid to go back to India? Okay. And then there's also the question of, if she did come legally, was there any gap? Is she illegally here right now? Did she overstay a visit? Okay. She's 17, turning 18 next May. Technically, there's no unlawful presence that's counted against her until she turns 18. Once she turns 18, the clock starts counting. All right. So she came illegally. So that limits her options. That means she can't apply for a student visa or like an H-1B visa. She would have limited options. Now, because she's already 17, turning 18 in May, adoption is not going to work. So even if you wanted to adopt her, that process would have to start before she turned 16. Now, if she was abandoned by one or more of her parents, that means they weren't able to support her financially, or there was some sort of abuse or neglect, then it's possible she could apply for what's called Special Immigrant Juvenile, or SIJ status, where if you apply for custody of her in state court with family court, then she could try to get a work permit or permanent residency through that process, but that she only qualifies for that if one of her parents abused, abandoned, or neglected her. So that's an option, but you might want to talk to an immigration attorney about that.
Thank you so much, Attorney Francis. Our time is up for today. Thank you so much for your time and for your very clear answers. And well, looking forward to see you in another show very soon.
All right. Thank you for having me.
Thank you so much. And for everybody that has joined us today, don't forget that you can call the phone number 216-279-3984, 216-279-3984, attorneys in the law firm of Margaret W. Wong and Associates. Thank you so much for having us, and have a good lunch and enjoy your day. Thank you.